May it be please, your lordship. Lordship, I beg to mention item number 5, 6, 7, and 8, lordship. In this,
7 and 8.
8, lord. Yes,
Four is
lordship.
also
Lordship, no,
connected.
in item number 4, Lordship, I am appearing. This item number 4 is already admitted. And this matter may be segregated from the other petition.
Lordship, if I may, in item number 4, Lordship, the issue is arising of the same judgment, my lord, for which a special
Common judgment, but
special division bench has already been formed for that, my lord. And the issue
Item number 4.
4 also, my lord. So it's all covered in the same judgment, my lord. And if
4, 5, 6, 7 and 8.
it's my lords,
So in very same judgment, a special bench is.
yes, my lords. Only
but
they were,
separately, Lordship,
they were
separate judgment,
different categories, my
different category, Lordship.
There were different categories of teachers, my lords, but all of them have been dealt with in the same common judgment, my lords.
But
Whether they are, the issue is, my lords, whether the teachers are entitled under benefit under the old pension scheme or whether they are covered by the new pension scheme, my lord. That is the main issue because, and in which there were different classes of teachers, various classes, my learned friend being one of them, my lord. And that this issue is being dealt with a special division bench formed for the education.
Do you have any objection in that?
yes, Lordship, we are from the 6th schedule area of NC Hills, Lordship.
Yes,
And our
the-
service
the-
condition is separate from the others petitioners, Lordship.
No, if the issue is the same, whether the class of employees are governed by the new.
Old pension scheme.
Old scheme or new scheme.
Yes,
Our,
the matter.
and that
our
has been
case
dealt
was
with it.
rejected only on the ground that we were, Lordship, serving under a non-pensionable establishment.
That is, that, Rashid, all the categories have been.
Issue, ultimately, the issue is only this, whether which set of employees are to be governed by the old or new.
Yes, my lord.
pension scheme.
And there were various,
It would
Others
be
not in-
appropriate that these cases be.
they have already been
still
listed
allowed,
for hearing.
that- Do you have any objection in that? I don't think so. There is, you should have any objection.
Lordship. But otherwise also it is already admitted, Lordship, and
Whatever it may be that.
There also it's for listed for hearing only.
They
Lord.
admitted and it is already posted for hearing. Again, they will hear this matter also.
Lordship.
The details of that.
Lordship, it's writ appeal 156 of 2023, my lord. That is the leading case.
Okay. Okay. Learned Counsel, the respondent has submitted that the issue involved in these batch of writ petitions. Appeals as well as in writ appeals is that whether the employees of the different branches are to be governed by the new pension scheme or
Old pension.
old
They're all
pension.
teachers, my lord.
It is submitted that who dealt with the same issue, a special bench has already been constituted wherein the matter is already at the hearing stage. Top view of the learned counsel for the appellants are not in position to dispute said position. In such circumstances, we deem it appropriate to list these writ appeals along with writ appeal number 156 2023 for hearing.
Lordship.
Lordship.
Item number 19, 17.
May I please, Lordship, I have already filed affidavit in reply. My respectful submission before your Lordship regarding the interim prayer
In which matter,
9-9. Your Lordship.
call it, it is only for adjournment. If you want any adjournment, you
No,
May I please, your lordship? Lordship, with the consent of the appellant, lordship, I beg to mention item number 22 of business, lordship. Lordship, I am appearing on behalf of A. Soma, standing counsel. Lordship 22.
you want
Right.
adjournment.
Lordship.
Time for the appellant, my lord. The date may be fixed, my lord, on 12 or
Okay,
14.
at the request of the learned counsel for the respondent. Matter be adjourned to so and so date, whatever date you want.
12, 12.
Obliged.
Obliged.
Daily list for orders, item 1.
Lordship, on the last occasion was pleased to direct the respondents to place the one-man committee's report This is with regard to that demolition of house by the police officers.
Well, I have received the report in seal cover, Malab.
Totally. I to mine.
No issue, to demolition with bulldozer. That's why not sure. This is what.
Demolition to building. We have all demolished bodies there. Everybody has also. All the. Bodies there. Yeah, excuse the Mora line. Bottom from the 18 the particular कैसे particular
पहले तो इसको सरकार ने एक्सेप्ट किया कि नहीं? This, what are your instructions, whether you have accepted this report?
But the report, my instruction is that report is on the consideration of the highest authority, my lord. It is with them, my lord. That is why it has been placed before the honorable court in a seal cover, my lord. Lordship may give us two weeks time, my lord. Let them take the their decision on the report, my lord. We'll apprise the honorable court.
इसको सिल कवर में रिटर्न कर दो। Okay. And counsel appearing for the learned senior government advocate Assam, Mr. D. Nath, has produced the one-man inquiry report before this court in sealed envelope. So which it is submitted that the report is under consideration with the state government, and the state government will take a call on the said report within a period of 2 weeks. Stop.
Look,
Mr. Nath. Place for and granted 2 weeks time to apprise this court about the weight of the inquiry report as well as the measures taken by the state government in response to the findings of the inquiry report. To stop the inquiry report submitted before this court be returned to Mr. D. Nath, Senior Counsel, Assam, in sealed envelope.
I'll apprise the honorable court about this progress report, my lord, status of the consideration. My lord,
Whether you have accepted it or
Gotcha.
not accepted it.
because I don't have the instruction that within 2 weeks they will complete. my lord.
4 weeks.
My lord,
Granted 4 weeks time,
Lordship,
fix a date after 4 weeks.
Lordship.
Return it in the sealed envelope.
I'm obliged. Lordship. Deeply obliged.
Item number 2. Public.
Lordship, please. It's a delay application, your lordships, in filing a writ appeal against the order passed by the learned single judge in 2018.
Yes,
I retired
how
from,
much delay?
it's 1,033 days.
1,033
33
days.
days. I retired in 2021 from service. I was in the Northeast in different parts of counterinsurgency as well as sensitive services. I went back to my hometown. And from there to come and contact a lawyer, I took some time to get myself all the documents,
How far
organize
your-
myself.
How far your hometown? is?
He went back to Agartala, your lordship, after his services. And he was there for a long
Northeast,
time.
Northeast.
Yes, yes. He was always throughout in Northeast. His services was an accountant in the Assam Rifle Services, your lordships. I'm only saying that, your lordship, this benefit that the reason why I'm here, because it's of a benefit that was supposed to be given to us and not extended
That
to
is
our
the-
notification.
that is The merits.
And on that, there has been a classification being made by the government in not giving that benefit to us. I'm only
That is
requesting
on
you,
merit. That is on merit.
I'm great, what I'm saying that, your lordship, this issue involved is this. These benefits are like a compensatory benefits that I'm supposed to get before serving in an insurgency areas. And for certain reason, I have been debarred from this
Why the
benefit.
learned single judge has refused to give?
Yes, your lordship. That order, your lordship, at this page of the writ appeal, your lordships, starts at page 41. And the relevant part is at page 55, your lordships.
पहले भी मांगा था और ये CAT का order है। CAT का। This is against the order of CAT.
We initially, the group went to CAT. Then they came here in a writ petition before the Meghalaya High Court. There was a set of petitions filed there. Then this order was passed subsequently. The single judge has rejected the writ petition on the ground saying that there's equal pay and
The
equal.
Meghalaya division bench has also dismissed the appeal.
Yeah, in that reference is at page 1, at page 55 of the
Then
decision.
there is a judgment of the Supreme Court which declines your prayer.
Yes, they are comparing, that's because they, with all due respect, your lordship, they said that it's regards to equal pay and equal work and distinguishes between competent and non-competent. We were saying that the benefit that is to be given to me in terms of an act, which is the rules that covers me, even if I don't fall under the Army Act or the Assam Rifles Act, that with greatest respect has not been considered by the learned single judge, which is 3(4) of the rules. They say that you are covered by the central government rules, therefore you do not come under this.
Writ appeals belonging to the similarly situated persons have already been dismissed by the
Yes.
Division Bench of Meghalaya High Court. What remains in this matter?
All I'm saying is, your lordship, in that division, in that order, they relied on the Supreme Court judgment to say that it's on equal pay and equal work. We were, with all due respect, we were not on equal pay and consent. We said we are
Analogy-
particularly in a different category of
Same
employment.
analogy will applicable in your case also.
With all due respect, it
If
may not
you
be,
are
your lordships.
able to- If you
That's the
not
classification they
entitled for
create.
Equal pay for equal work, how can you ask for the equal treatment?
That's the classification that they create by the notification. They are saying combatized and non-combatized. They are saying people who are in service with the combatized, and I face the same hardship, but I'm not equated with them.
That, give us the writ appeal.
If the order of Meghalaya single judge is there in the writ appeal.
No, your lord, that I have not, is not available here. There's a reference at page 55 of the order, but that's writ petition number 120 of 2000. Similar, there were 2-3 writ petitions filed before the Meghalaya High Court.
Oh, writ appeal, yes.
That is subsequent. Subsequently, there is another order for division bench.
मैंने ये राम गोपाल अगर
24 hours. That means there was supposed to be the CPMF. The request notification.
This is not a CAT order, this is,
No, the High Court order.
but there is an order of the
Yes,
CAT.
page
also.
55, your lordships.
There is an order of the CAT also.
Is there was a CAT order? We haven't filed it, your lordships. I'll have to check on that. This is, this arises in circumstances of 3 writ petitions that they filed in the Meghalaya High Court. At that point of time, these are writ petition 120. It's mentioned at page 55 of the impugn order. Paragraph 15. In fact, the ground taken by them was that they should have gone to CAT and not to the High Court. That is the
Concern, we not find any error in the judgment of the learned single judge. It is based on the Supreme Court judgment as well as the Meghalaya High Court, division bench judgment.
May I say this, Your Lordship? When initially the ration allowance was introduced in 1998, that was supposed to be given to the Central Paramilitary Forces. Subsequently, in 2020, 2009, when this notification was introduced for the first time, that is where the classification was brought into phase. Now, my grievances, Your Lordship, because of this classification, I have been taken out. I face the same equal hardship. I am in the same camp. I do the same work with the same combatized personnel. So my differences was created not because of this.
Notification,
Yes, Your Lord, that notification is on 65.
dated.
That is 24th of February 2009, page 65.
So why you ask for this quashing of this notification?
Because, Your Lordship, the benefit that is supposed to come from me is supposed to come from this notification. Who are the setting aside of this of the High
By
Court order?
filing the petition, does the petitioner seek quashing of official remuneration?
Yes.
24th of February, why you are, when
Yes.
you are saying.
I'm
that as
also,
per this notification, you are entitled,
No.
then why you have asked for quashing of this notification?
I have also asked for the setting aside of the order of the past with the learned single judge. Along with that, I have asked for that.
Why you have been
Let's see.
benefit from the people?
So since the benefit has not been given to me, for that notification,
No, this notification introduces the classification or
combatized, non-combatized, whereas the benefit is the ration allowances. So my case is if the classification is created, it takes me out of the purview of the notification because I fall into a non-combatized. Though my service is similarly to based with whatever the other people are doing.
restricted the ration allowance to the combat. And therefore, he wants to check.
In fact, the pay commission also supports my contention and a pay commission gives me that finding.
We are not satisfied, sir.
May I just read 128 with your lordship's permission, page 128 for a minute, if your
Yes.
lordships have. This is the pay commission report, your lordships.
Yes,
And at the end of page 128,
yes.
ration allowances to civil staff. Now I fall into the category of a civil staff. Assam Rifles civil staff are not granted free ration in kind of all allowances as offered by the civil staff in SSB jurisdiction. The civil staff of Assam Rifles are performing their assigned duties side by side with the counterpart of a combatant staff and in the field of the Northeast region. They perform duties in remote localities, in far-flung areas, in difficult environment, in the center of the road, communication, medical facilities, and school. At all times during the operational commitments, roadblocks, main-met situations, they are compelled to subsist the poor quality and ration supply stores. It needless to explain the duties performed by the civilian staffs of the Assam Rifles are similar to the combatants without observing the Sunday holiday, splitting the designated week hours and disregard. It is therefore fair that all the facilities available to the Army AR personnel are extended to the counterpart civil police. This is what ultimately the report.
What happened in that report, whether this recommendation was accepted or not? Then
In fact, the notification which is now coming up of 2000, which was challenged before the single judge, your lordship, that's the notification which creates the classification in spite of this. And in fact, this,
yes. Okay, the matter comes upon for consideration of the IM pursuant so with the prayer for condoning the delay of 1,033 days.
great.
1,033 days, we finally reconnected appeal. Full stop. The application for condonation of delay. The main reason given by the council for the given by the applicant is that though he retired from the services on which date you retired from the services?
Lordships, I retired on 3621, page 7 of the
On
application,
30th of June 2020.
2021.
21. But Soon thereafter, he left for his native village in Tripura and stayed there for some time. He submitted that on account of lockdown and travel restrictions in all the state of the country, he was unable to travel to Guwahati to meet his advocate to take further legal recourse against the impugned order. It is further submitted that the writ petitioners in the writ petition filed by the petitioner along with other persons are natives of different part of northeast region and Jammu and Kashmir.
You have nothing more to say?
And some time was taken and a lot of time was consumed in seeking consensus of all the writ petitioners to challenge the impugned order. Stop. It is further submitted that when no consensus have arisen between all the petitioners, the appellant decided to proceed with the further legal recourse on his own, and thereafter he met. He arranged a meeting with his advocate in July 2022 at Guwahati. And thereafter, Guwahati, however, the advocate requested the applicant to come after a few weeks. And ultimately, in October 2022, precisely on 7/10/2022, the case was presented, the writ appeal, along with this application for condonation of delay. लिखा वापिस बताना। He had a meeting with the advocate. However, dissatisfied with the said advocate, the appellant wants to engage another advocate for consultation and taking further legal recourse against the impugned order. And ultimately, towards the end of December 2022, he was informed about present set of concerns. But at that time, ensuring winter and Bihu vacations. Bihu vacations, April में नहीं है? ये January में तो- The applicant could not get an appointment. Towards the end of January and unable to meet his advocate in the second week of February. Thereafter, the brief was prepared. And presented before this court in September 2023. Full stop. पूरा डिटेल्स दे दिया, कोई एडवोकेट का नाम भी बता देते। You just inform the advocate that you were not satisfied and then you consulted that advocate and everything. Story is good, but not appealing us. Having gone through the contents of the application and after hearing the learned concept of the applicant, we are of the view that the applicant has failed to explain the use delay of 1033 days in filing the connected rate appeal satisfactorily. Vague assertions has been made in the application without there being any details. Hence, no case for condonation of delay is made out. Stop. Otherwise also, the impugned order passed by the learned single judge is also not liable to be interfered with, as the learned single judge, while placing reliance on decision of the Honorable Supreme Court rendered in Union of India versus Ram Gopal Agarwal, 1998 to SCC 589, has non-suited the petition, non-suited the applicant. The learned single judge has also placed reliance on the decision of a single bench of Meghalaya High Court as well as the decision of the division bench of Meghalaya High Court.
Hmm.
In such circumstances, we also, we don't find any merit in the writ appeal also. Hence, the IA number so and so is dismissed, and consequently, the connected writ appeal is also liable to be dismissed as being devoid of any force.
Great.
For admission, item 3.
May it please your lordship.
Yes,
My lord, so far the grievance of the petitioner is concerned, that now confines to the period of 2020 to 2023 up to. Because recently, after filing this, I have got an order, I have been treated equally with others for 24. 24, yes, similarly placed, all are given similar orders. But so far, kindly come to page 18 of my petition. I have given the chart.
page
18 of the writ petition, that 37 para. Lordship will find. Page 18,
yes,
paragraph 37. I have given a chart here from 2020, then 2021, 2020 to 2023. Here Lordship will find we three contenders. I am GLJ. Others are GLR, GLT. So far, number 1 and 2 column, kindly see, Central District Court Libraries, SD James Court Libraries, we are all treated equally. I have no grievance. Then comes all judicial officers where the big number of volumes are concerned.
Just a minute.
Therefore, in the third column, all judicial officers category, There I have been denied.
Denied for which year?
2020.
2021.
Now you are coming for 2020 in 2024.
True. Well, lot many representations. RTI was also filed. Those were rejected, denied, then appeal filed, ultimately given. Ultimately given.
Mr. Ponson, what is your right to, as a matter of fact, you can ask
No,
give
I
me
am-
the orders for supplying the
I am-
copies of the generals to the
Yes,
judicial officers?
well, these journals are subscribed by this honorable court, very strict.
Fine. That is the choice of
They-
the High Court, which general is to be subscribed and which
Well,
not to
if
be subscribed.
Now, it is a fact demonstrated on record that all these three suppliers were treated equally all throughout. Suddenly, in respect of one category, I am denied. I made a prayer that kindly let me know if there is any deficiency on my part, or if there is any better service rendered by some other part, so that I can also improve. Because it is a competition, commercial
But why
competition.
now? Why
Fair
2020 claim has been raised now?
My claim is that I have been discriminated without any reason. Is there any ground? There is a good ground if I can be subjected to a different group from them. That look, these are the deficient,
No, no, your
intelligible
plea
differential.
probably could have been genuine at that point of time. Now, this extension has been given on representations made by two of the journal operators. So it has been extended equally to your client also, without even asking for it. Others have asked
I
for-
asked for, my representations were there, but then 2024, I
Now,
am told
after
right
all
now.
this, you are now going back to 2020.
No, that was already there, my prayer was also that I should be considered for 24 also. That is why I opened my mouth saying that after filing, I got an order that yes, 24, equally placed, I have no grievance, that part is concerned.
Happy with that.
But my lordship will kindly consider. All these orders were not given immediately every year. It follows after a year or even more than a year. Now those orders follow, that's how the delay arose. 2020, orders were issued 2020, 2021, orders were issued in 2022. This is how things go.
That will take care of that in future.
Therefore, my responsible submission, lordship will kindly see. After all, there has been a grievance in the mind that probably this is not treated equally. That feeling has come. It should not be allowed to sustain. It should be removed because in dealing with such things, after all, this is also a kind of state largesse. And there must be some procedure fixed, madam. Without following any procedure.
Why has that feeling come now? That's what we're asking. That
No,
would
no,
have come in 2021.
Well, I appreciate your lordship's question. That is obviously will be put to me, but my answer would be simply that I had to wait till a certain time by making representations before the authority kindly consider, and ultimately when it didn't result anything,
So now
and
in
it appears to me,
2024, the orders have been placed. For the year 2024 now,
my instruction is that the order has been received.
so we have corrected our mistake.
Malad,
Earlier
that-
mistake, what we have corrected.
well, that my responsible submission would be to your lordships, what has fallen for your lordship. Probably that has been corrected. There was some discrimination, there was some non-consideration was not in the proper line. Probably
That's why
that
only
is
we felt it, and then therefore now we have placed the order to you along with the others. We
All
also
right,
felt it the same.
well, I have no grievance so far the others are concerned. I only want a similar treatment. If I stand differently, that should also be
So
told
now
to me.
you provided, you have been provided similar treatment with the others
Right from this year, yes.
right from this year.
Yes.
So we have corrected our whatever your grievances. we
True,
have-
my lord, true. In that, following that principle, If,
But for
why
the-
not my
for the
cases can be
years
considered for other
2020,
periods
21,
also?
22 and 23, now we can't give any order that supply is the copies of. for,
Budget
uh,
was lapsed.
Bad volumes, this honorable, what is
There is
the,
no
what is
budget
the
for
difficulty
There is
in
no budget,
considering?
budget has already been elapsed, even though if we want, we can't give any such direction.
Well, that of course, that side, I am not privy to it, but then my only concern is, they can consider, why not?
How can we consider when the budget is already
Subject to,
subject to, there is no such budget of the previous year, sir. We can't have. And we are asking for the budget while projecting the day-to-day expenses of of the coming year. Not for the previous year.
what I find, আমি এত বছর পিছনে দিয়ে করেছিলাম,
Mr. Mahanta,
my lord,
this extension for 1 year, it came to you as a bonus, and we know what exercise was done for that. A judicial order would not have got you this relief for this year also. Nowadays, the financial mechanism has completely changed. There is no question of placing order for 2020, 21, 22, 23 and these fund. Question doesn't arise. The High Court is having to deal with many issues, which we don't say that it is unwarranted, but the earlier laxity in the operation is gone. So you argue, pass our orders. You have also the option of
I-
withdrawing it.
no, I'm grateful to your lordship, that lordship has.
That's the
disclosed it,
reality.
Thought it
That's the
proper to
reality.
disclose it to me. But I understand it.
The reality is that.
Well, things should improve. That what
We'll take
lordship
care
has
of that on the
indicated,
administrative side, certainly. we'll take
that
care of
what has fallen from your lordship, probably that is good.
Yes.
That is good. And that there were some loopholes here and there.
We'll keep in mind, we'll keep in mind. the
That
grievances
has been
raised by
reflected
the-
here.
raised
That is
by
my
the
grievance.
people By this petition, and we'll try to correct,
Streamline things, my lord, then definitely nobody will have any grievance on that.
we will try to correct.
Nobody will have any grievance on that. Despite asking for, nothing comes forward. Obviously, it creates more confusion, miscommunication. That happens. That happens.
No, you're right on that. Only problem is today the relief you are seeking cannot be granted. Who will bring the money for that? That is
of course-
gone.
That of course, now again, my lord, if this is the, my lord,
वही मैं पूछने वाला था, but I can't ask.
One thing,
my lord,
you see, you supply us all these volumes of year 2020 to 2023, and will gracefully accept it.
Of course.
Without paying any cost, because now we can't do that. Yes, certainly it will end, and this volumes will enrich our library of all the judicial officers. You provide us, we'll gracefully accept it.
my lord, to that extent, if it can be done, I will definitely advise that it should be, but
Yes,
I will have to take the instruction.
yes.
to that
This is your
extent, but-
instructions, You supply us
but-
free of cost,
but let-
and will supply to all the subordinate judiciary.
My lord,
Certainly, it will enrich their library
my lord,
of 2020 or 2023. All the volumes you please supply us free of cost, we'll
Well,
accept it, sir.
then again, my lord, if somebody volunteers for that, of
Somebody-
course. If a particular supplier volunteers for that, gracefully to do this within his capacity, of course, it is always welcome. It is always welcome. But when he seeks a relief,
Which relief we
not
can't give
being
now.
treated, that is what your lordship has said, that probably because of the change of the financial regulations,
Yes,
positions, now it is not possible. I will only place before this honorable court that if this honorable court feels that during that period, which has been denied to the petitioner as per the allegations made, if this amounts to unfair treatment, that may not continue to happen.
Some instruction might be coming for you.
No, not yet. Not yet, my lord. Not yet. So,
on the way, on the way.
My responsible submission is certain big businessmen, yes, these people, they strive on this limited budgets.
Now this paperless days, in the coming paperless time, why don't you shift your business to some other?
Sorry, Malik.
Sir, now in the time of this paperless, whole paperless thing,
Yes,
you should also think of changing pattern of your business. This printing business is not
Well,
much.
exactly. If this honorable court, the administration decides to go to be paperless all throughout in subscription also.
It is, that is the decision. 24 is an exception. You are not, nobody is getting it from 25. You please.
I
read
see.
the
From
decision.
25 only paperless. And
Absolutely.
then everybody will prepare for that. This message goes to everyone.
Yes,
Everybody will
everyone, we have
prepare for it.
already communicated this message to everyone.
Yes, then everybody will be prepared.
To every publisher, we have already conveyed this message.
Then there will be no grievance for anybody.
Yeah, naturally.
But so long that is not done, there remains some loophole here and there. It creates a problem. That's how this petition is before your lordship. Lordship may not take it otherwise.
We have already understood your grievance, but the thing is that now, even though if we desire, we can't give you the relief. That's the sole problem.
Then in that case, probably I should press your lordship, so lordship may record that. In view of all this change of situation, this prayer cannot be granted now.
Why you invite a judicial order on this point? Judicial order, that's not entered.
24/7. Yeah. Just a minute, lordship. I'll take the instruction. Because these changes coming, expected to come quicker,
Bound to come,
ultimately has come,
bound to come.
ultimately has come, and obviously, definitely on someday, it will be implemented, it will happen. But people should be ready for that, and this should be made known to, that yes, you prepare.
2022 full court decision is there on this. Everybody knows about it. It is on extension now.
I'm sorry, I am an exception.
Maybe,
I did
maybe,
not know that.
maybe.
I did not.
All
I did know.
all the journals were informed about it.
I did know only this much, that court is trying to make the courts paperless. And I was trying to make myself.
No, it's not about
adaptive.
paperless. Paperless, obviously. There are multifarious problems. You don't have storage space to keep the books.
Yes.
Then other issues are also there.
True,
It's a policy decision. It's not to do with any individual.
true, Malan, that is right. I appreciate it, sir. Obviously, these institutions must function under certain policy. And that has to be done, and once it is made clear, everybody knows it, then everybody will be prepared for it. There'll be no-
There is a full court decision. Are you aware?
That full condition I have not aware, my lord. But
They're all
regarding
based on full court decisions.
So, Malad, I'm sorry, firstly, that the graceful supply, that will entail a cost which is difficult for my client to bear it.
We understand
So,
that.
sorry that he could not accept it.
It's okay.
And so for the other part is concerned, Lordship may pass an order anyway, or one day time, I may be given to take instruction whether I will face it or withdraw it.
Monday.
Monday.
my lord, that is your Tuesday, my lord, Monday I will not be available.
Yes,
He
yes.
has to complete his instructions. You have nothing to do.
My lord, sorry, my lord.
You are not supposed to do anything.
My lord.
Yes, yes. And in case, my lord, personally, I may not be before your lordship.
Yeah,
Why
anybody,
it's-
anybody.
Obliged.
Item number 9.
Maybe the lordship. I have already filed in affidavit in reply. In this case, in this case, regarding the promotion of to the Director of Economics, as per APSC advertisement, we challenge the APSC advertisement. Your your lordship may kindly peruse.
May I please, your lordships?
Yes.
In this case, lordship, Deputy Secretary, Government of Assam has requested to take 15 days time to take decision regarding letter submitted by the director for consideration of the amendment rules.
Now, lordship, there is a urgency regarding the stay. Your lordship already published in the Assam Tribune. In the month of March, fixing for Haibabus.
Where is the stay application?
I have already paying the stay. Your lordship may kindly.
There's no stay application and along with this.
Stay petition is not filed separately in the petition. There is,
Petition, you are not required to file separate.
no, there is a clear
Read appeal.
repetition. Your lordship. Pending the disposal of the repetition, your lordship may kindly be pleased to stay the recruitment process initiated through the advertisement dated 25/8/2023 Assam Tribune, Annexure G, issued by the Assam Public Service Commission for the recruitment for the post of the Director of Economics and Statistics, Transformation and Development Department, Government of Assam, till the disposal of the repetition. Page number 22. Page number 22. Your lordship,
You have prayed for staying the recruitment process.
recruitment process.
That has already been over now. The recruitment process is already over.
No, my lord.
The recruitment process not over, my lord. What happened in this case, my lord, advertisement was published on 25/8/2023.
Yes.
Then, my lord, last date is over, my lord, 30/9/2023. After that, my lord, the petition has been filed. Even, my lord, last date is over. He is challenging the my rules. Advertisement was published as per rule, amended rule of 1995. So that has been challenged now, my lord.
Then he can challenge.
Yes, my lord.
He is agreed, he can challenge.
So this approach was made, my lord, before this honorable court
Now,
after the last.
What stay you are seeking now? What stay you are seeking?
Advertisement, page, newspaper publication.
Newspaper publication of what?
That is advertisement. Advertisement.
Advertisement. Annexure.
Any, what stay you are now praying for?
To stay the recruitment process.
To stay the recruitment process.
Recruitment process as advertised by the,
The recruitment process will be subject to the decision of this writ petition will observe this. Can't stay the recruitment process.
recruitment process.
Will not stay the recruitment process, but will observe that the recruitment process will be subject to the outcome of this petition.
After March.
That we know it is innocuous order, but still will pass this order. Having heard the learned concept of the parties, we are of the view that matter requires consideration. Hence, admit no need to issue notice as parties are already represented. However, the parties are represented. The recruitment initiated by the respondent pursuant to the advertisement dated 25/8/2023 would remain subject to the final decision of this writ petition.
Item number 10 to 12.
Last time. you were
Yes,
supposed to-
I had a discussion. I had a discussion with my client, with my learned friend. I didn't interact, my learned friend interact. He said 15 lakhs, they can pay it, maybe up to 40 to 50 lakhs, but 15 lakhs
Maximum.
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 For 15 lakhs is the amount. But rest is again disputed. I said, how come? Then I have seen the recommendation of the Majidia Wage Board. There are certain class of newspaper establishment, about 8 classes. One class is about 1 lakh, 1 crore, 1 crore is the last. Then is 1,000 crores, depending on the income they generate, and accordingly multiplication is done, employees are paid. So it's a huge task. So I said, please work out. So 15 lakhs, that's for the reason, my lord, when we move this matter, 15 lakhs, we asked the court,
deposited.
yes, that's why we deposited. Rest my lord, this is a dispute. That's all, Learned Single.
Is ordered for paying of 25 lakhs.
Yes,
But if you are admitting that 40 to 45 may be maximum, then why not 25 lakhs? What's the problem?
my lord,
If you are admitting.
no, I'm not, no, I'm not admitting. I'm admitting only 15 lakhs is admitted amount, 15 lakhs. Rest is again a calculation, huge calculation. Huge calculation is there. That's the difficulty, my lord. I think Bhattakur, the council, he just said that he is in some other court.
Pass over for the day.
Yes.
See you on the next day. Like.
For hearing, item 13.
May I please your lordship. My lord, in this matter, we are challenging the virus of the rule, by which my lord vested rights of the members of the petitioners association have been taken away, my lord.
This petitioner association is the association of all engineers working in the town and country planning.
True, my lord.
So engineers would include assistant engineer, executive engineer,
Yes.
as well as superintendent engineer.
True, my lord.
Now you are aggrieved by creation of this post of superintendent engineer in the.
No. Superintendent engineer post was created long back. Now it has been permanently retained. My lord, may I just indicate, there was a promotional avenue to the post of director. Director is the administrative and supervisory control.
Correct. So now it is promotional avenue to superintendent engineer.
No. There are 3 wings, planning, research and engineering. And all officers from the 3 wings were entitled to get promoted to the director. Now, my lord, by these impugned rules, only for the planning wing, the officers can go to the post of director, other 2 wings cannot. And there are other issues also whereby, my lord, promotional avenues have been curtailed. That's if there is a charge.
This director,
My lord.
the promotional post is also a member of this association.
Yes, sir. Lordship, may I indicate there is a chart annexed that will clarify.
No, that's not the point.
Right.
There is a conflict of interest amongst your members. You cannot maintain this petition as association. That's the point. Somebody is getting the benefit, somebody is not, and all are part of your association.
No,
That's the
my-
problem here.
No, the entire engineers as well as the, my lord, researchers has been, my lord, thought.
Excluded. Entire engineers and the research officers have been excluded.
Excluded, my lord.
That's right, but the engineers, the planners are only entitled for the avenue of promotion on the post of director.
To the top post.
The planners are also members of your association.
No, my lord. Planners are a different wing, my lord. There are 3 wings under the Assam Town and.
Assam Town and Country Planning Engineer Services Association and another.
My lord, this is Engineers Service Association.
Only engineer services
Yes.
this association belongs to, and director is also one of the.
Earlier there was a service order. The director was the topmost post and from all the 3 wings, it was open for that. Right now, by the impugned rules, they have, my lord, excluded the other two wings, only the planners can go to the post of director. So the vested right, as envisaged by the service order, has been taken away by them. As page 84, we have given the chart, my lord. Your lordships kindly have a look at page 84.
Correct, it's litigation.
So, as
The synopsis, which all required, like, petitioner, the approaching. We have been responding. Parties are opposed to and probably to that better postal director. ये देखते हो
If your lordships permit me to point out one thing, yesterday, another additional affidavit was filed on behalf of the government. In support of the rule, whether there is on record or not, I am not very sure. Otherwise, we have extra copy.
Yeah, filed the additional affidavit clarifying what?
Clarifying, well, basically justifying the reason for which the post of superintending engineer is not the feeder cadet for the post of director. Now, it's a town and country planning department. Planner job is the most important job here. Engineers are there. There are three different service rules. Initially, there 1990 there was a service order. It was in between there were some litigations and possibly they are relying on some observations made in some of the judgments that the two posts are equivalent otherwise. But so far as making the post a feeder cadet for the post of director is concerned, my lord, initially in the 1990 service order it was there. Equivalence was there, but not the feeder cadet. Subsequently, after all these litigations, the Supreme Court has observed that government must come up with specific service rules. And these rules are framed under a proviso to Article 3 and 9 of the Constitution of India. In these rules, Lords will find qualification is different for the post of planner in the service rules. Now, planners go to the top of the department, and in the service rules for the planners, the post of joint director is the feeder cadet for the post of director, who is at the top of the. So far as the researchers is concerned, the chief researcher is the top post. Beyond that, they do not go. Similarly, in the engineering wing, my lord, the top post is the superintending engineer. Beyond that, they do not go. In the additional affidavit that we filed yesterday, we have clarified, we have tried to justify the reasons for which the superintendent post engineer is not the feeder cadet for the post of director. That's what I asked for.
Counsel for the petitioner has submitted that an additional affidavit is filed on behalf of the state yesterday. However, the same is not available on record. registry is directed to place the same on record and list this matter on
After vacation,
I go to it. 16 of the The matters are pending since 2016, my lord.
21st of March. Which, we- 28th of March.
Deeply.
8 years. April.
Item 14 to 17.
May I appear, Lordship? Lordship, in this case, I will seek some accommodation today, Lordship. Lordship, what has happened, Lordship? There is an order dated 25/8/2023 passed by this honorable court. In terms of that order, we were directed to file a representation and they were directed to dispose of the same within a period of 6 weeks. Lordship, my learned senior has handed me a copy today because it was not communicated to the applicant.
They already decided your.
They have decided, they have gone against us. So Lordship may give us some time. Lordship, let me obtain the instructions on this.
Learned concept of the plan. Submitted that. Pursuant to the direction given by this court on 25th of August 2023. The appellants have submitted a representation before submitted representation to the Chief Managing Director FCI.
Okay.
And the same has now been decided. He has submitted that. He placed some, full stop, he placed some time to complete his instructions. Time plate for is granted, list on
Okay, can it be on 22nd of March
22nd of March.
of that person?
Item 18.
May please your lordship. The matter
Dealership. Lost time to या तो कितने जमा होगा 15 साल का लीज दिन प्राइवेट रेस्टोरेंट में 15 साल का खाते गवर्नमेंट पास का है जनरेशन का लीज नहीं जो लीज दिया है वो वैलिड लीज नहीं है क्योंकि इधर ही में एक आदमी का नाम उससे इनको देखना पड़ेगा कंपनी को देखना है सुना नहीं Before another bench, if one of us, मेरा नाम भारत पेट्रोलियम कॉर्पोरेशन है
Item 19.
Not been able to hear the case. I can fix a date, sir.
Lordship, in the item 19, Lordship, some correction needs to be made in the cost title because the Hojai College is no longer a college. It has been upgraded to an university. So I have to correct the cost title, Lordship. Respondent number 3.
But this has not been admitted yet. There is order to use for here. Matter can be heard.
Okay, then it consent for the. Well, I'll place some time to make necessary correction in the, cost title.
Cost title.
In the cost title. Time paid for is granted. It is noticed that the matter is still not admitted. List for the admission on so and so. Admission get a, will fix it for admission.
Item 20.
In earlier occasion also, this honorable court severally requested the council to consider the case of the petitioner. That and 22nd of 8th of December 2022, my lord, this honorable court's order. Then 19/1/2023 of and thereafter also it was severally requested to the council to comply with the honorable single bench order, madam. That's
Dispute is regarding
Resignation, whether that was given voluntarily or not. That is
resignation.
resignation.
that part already been discussed. There was a standing committee, my lord, when the record was called for, my lord. Then it was found that no such statement was recorded from the petitioner or no such opportunity was given whether he rendered his.
There is, just a minute, there is a judgment on more or less similar issue in the single bench. It was authored by me. Are you aware of it? CRPF matter.
Yes.
I think it is a judgment of January 2024.
Yes, yes,
This year.
Where this aspect has been dealt
This
with.
year, Lordship.
yes,
Voluntary discharge,
yes.
resignation, what would be the impact under the rules? But that was under the CRPF rules. This is also CRPF,
No, this is Assam Rifle.
Assam Rifle.
And Honorable Single Judge has relied on CRPF, that's applicable to CRPF. But we have our own record of instruction. We follow that. Lordship.
That CRPS, my lord, this principle, when undertaking has to be taken, my lord, that has to, in the undertaking, the authority has to ask the petitioner whether he is going for voluntary retirement or not, whether he is given the resignation.
That's the
or
only
not.
point the learned single judge has interfered.
Whether
there is
that
no
disputed
finding of
fact should have been
voluntariness.
entered into or not, that is Lordship.
Yes,
one of the
that
aspect.
principle has to be followed, that
And
part.
here the dispute
That
was
has been
with
already on perusal of record, that has been discussed. And no such record has, this statement has been found that he has given.
And there is another judgment which has declined relief because of the period during which he was out
It's
of.
1.5 years. Yes, of course, he has annexed one document, but it does not boost confidence within 90
this
days.
is-
That come within 90 days,
This discharge was in 2011.
Lordship.
So.
Passage of time, with the passage of
Please
time.
look at those judgments also. These are
Lordship.
of this court's judgment.
And
That, 10 साल 12 साल हो गया अभी force में दोबारा उनको-
Whether relief can be granted after certain.
I think there is a appeal pending before this court on that.
Appeal is of Lordship. 1921. Otherwise, lease is pending since
No, no,
2000
understanding, there is another matter where this issue is
pending.
pending, that even if he makes out a case, after 10 years, he cannot be directed to be reinstated in the service.
And once the muster and that's relation has been severed by accepting the weather that can, I
So
rely
where
on
are
that
those
judgment also.
judgments? You have those judgments.
No. I have also some of the judgment, my lord, where this resignation has been tendered, whether it was voluntarily or not. And that part, my lord, already been when the honorable court perused the record, my lord. On perusal of record, it has been found that for whatever this appellant said, that was totally misconceived, my lord. It was not there, my lord.
It is your case that you were forced to.
Jake, my lord.
For what? Why?
Because, my lord, in the month of April 2011, my lord, my wife was suffering from gynecological problem, my lord. And that is why, my lord, with the request of the Subedar, my lord, the immediate authority, on the, I went to the hospital, my lord, Assam Medical College Hospital, Assam Medical College at Dibrugarh, my lord. And after 3 months treatment of my wife, I have come back, my lord. Thereafter, whole issue arose, my lord. Then already I submitted all this medical report, my lord, regarding my wife's problem, and they have accepted it. And subsequently, they called me to tender my resignation, my lord. And accordingly, my lord, on the same day, 11/8/2011, my lord, 12/8/2011, my lord, same day, on the day of submitting my application, they constitute a standing committee, same day, on 12/8 itself. And same day, they hold the meeting. And the same day, discharge was made, my lord.
So what's wrong in that? If they done it wrongly, what's wrong in that? You should be happy that they would
that's
considered and disposed
yes.
of the matter on the very same.
By that time, he has already 4 red entries, lordship.
No, that part, had there been the red entry, my lord, this
Altogether another thing.
Yes, another thing,
You
my
should have dismissed him from services.
yes. Then, my lord, after that, my lord, my medical 3 months, this absent period, that has been regularized after being removed.
That's fine.
And now, my lord, that part, my lord, when standing committee took a decision, my lord, at least on this that particular point, whether the resignation letter was voluntary or not, that part, my lord, has not been taken into consideration, my lord.
नहीं जाते कोई lynching evidence नहीं है सर इसको force किया.
And that
it's a disputed question. If he is conclusion that this is being able to accept such a conclusion by the committee, the petitioner is voluntarily applied for lynching evidence.
in single bench of Honorable Justice Rishikesh Roy, my lord, 2017, my lord, the same way CRPF, it was considered and they reinstated the petition. Vishwarupa Mukherjee, probably. My lord, I take to your lordship the judgment, my lord, single bench judgment, my lord. Para 26 lordship and 28 lordship. In 25, para 25, my lord, page 94. In this regard, a reference has been made by the learned counsel for the petitioner to a circular issued by the CRPF to ensure that any such application sought for discharge or seeking voluntary retirement is to be considered by the authority to ensure that such application is not submitted under duress but purely on voluntary basis. In this regard, it has been submitted by the learned CGC that the circular is not applicable to the Assam Rifles but to the CRPF only. Now 26 law. This court is of the view that that is a too technical objection and the Assam Rifle Authority ought to apply the same principle while considering such application for voluntary discharge as raised in this petition. This court is of the view that
the standard adopted in other paramilitary forces can also be held to be applied for the reason that it merely lays down certain precautionary measures to be taken by the authorities before accepting any discharge application by ensuring that such application was made voluntarily. The aforesaid circular has been issued for the benefit of the employees. This court is of the view that there is no reason why similar criteria or principles should not be adopted in the Assam Rifles also, even if the said circular was issued exclusively for the CRPF personnel and not applicable to the Assam Rifles. This court is of the view that any procedure adopted by the authority while taking any administrative decision must be fair, reasonable, keeping in mind the mandate of Article 14. Therefore, these precautionary procedures can be read into the existing rules of the Assam Rifles for the Assam Rifles Authority, or the authority cannot.
Shows the this procedure in the Assam Rifles for the purpose of this voluntary.
Procedure, my lord, there is a procedure that the Assam Rifles rules is there, my lord.
Where is that?
And that rule has not been followed in the case, my lord.
Where is that?
Yes,
Which is
Lordship, Lordship,
How it has not been followed?
Lordship. I have also stated in my affidavit, my lord, Lordship, that is Assam Rifles Act 2006. My lord,
But this is not the finding of the learned single judge that this provision of the act has not been followed.
no, my lord, only the honorable single judge was came to the conclusion on those 2 points, my lord, that regarding circular, my lord, that circular was issued by the CRPF authority. In that case, honorable
What made in the mind of the learned single judge, it seems, in the absence of any material or documents on record as to how committee has come to such a conclusion.
Yes.
This court is not able to accept such a conclusion by the committee that a petitioner has voluntarily applied for discharge.
Yes.
This is what the.
Yes, that point has been decided, my lord. Only that paragraph 28 of this judgment, my lord, it has been clearly said, my lord. Para 28, lordship, of the judgment, my lord. Perusal of the said record do not indicate that the petitioner was personally examined by any of the members of the standing committee to ensure that he had given his discharge application voluntarily, and that the committee had given the finding that no undue pressure by any authority has been exercised over the individual who had applied for discharge from service, and that he had done on his own wisdom after examining the relevant and concerned persons, including the applicant. Next, well, in absence of any materials or documents on record as to how the committee had come to such a conclusion, this court is not able to accept such a conclusion by the committee that the petitioner had voluntarily applied for discharge. The main issue was there, madam. There is nothing on record to indicate, as mentioned above, that the members of the committee had interacted with the individual concerned or any other members of the unit. Therefore, if such finding has been arrived merely on the basis of examination of the application, which seems to have been done in absence of any other material in this regard, this court would hold that the finding given by the standing committee cannot be said to be proper. Non-application of mind of the standing committee on the particular issue of voluntariness of the petition is quite apparent on the face of the records. The undertaking given by the petitioner also has nothing to do with the issue as to whether he had given the application voluntarily, as the said undertaking was given only as regards his entitlement of his pensionary benefit. Therefore, this court is satisfied that there was no attempt by the authorities concerned to examine properly as to whether application for discharge from service had been voluntarily given to the petitioner or not. Well, only the issue involved, yes, the voluntarily he resigned or not. Since the question arose, and on this point, the standing committee was constituted, and the standing committee did not even taken any evidence or taken any statement of the petitioner, whether it was voluntarily or. It is a settled legal position that if the initial action is not in consonance with law, all subsequent and consequential proceedings would fall through, for the reason that illegality strikes at the root of the order. That the legal maxim was there, sublimatum fundamentum credit opus. Meaning thereby that the foundation being removed, structure wall falls come into play. This is 2011-14 SCC.
So he was discharged on 12th of August 2011.
Lord.
Then he approached the High Court for the first time in the year 2013.
Yes, he initially he approached.
Why was the delay? If it was not voluntary and he was forcefully
No,
turned out.
he submitted his application, my lord, in 2012, my lord. 13,
9/1/2013.
9/1/2013. And my lord, that time, my lord, and initially also, another application was submitted by him. Before he is discharged, my lord, he was discharged on. August 2011, I submitted one for withdrawal of my resignation. And in their discharge order, my character of.
Please, yes, so now.
Lordship, Lordship, in this case, he has applied for voluntary retirement on Lordship 12/8. Now he has relied on the next one document that is 26/8/11. He said that he wants to withdraw, but that does not bear any acknowledgement, nothing.
12/8/2011.
12/8/11, he applied for resignation, voluntary resign.
Yes.
He claimed to have filed a petition application on 26/8/11. That will Lordship will find at page 39. The vernacular at page 40.
Page
40 of the memo of appeal, Lordship. It does not bear any seal and signature of the office, whether this has been received or not.
First of all, his application for.
He want to withdraw,
No, his application for voluntary retirement is.
Lordship.
At page 31, my lord, there are two types of.
31 and 32. 32 is the vernacular, Lordship.
It's a vernacular is different, my lord.
The translation is, Lordship's a little bit.
No,
31.
31. In 31,
32 is the, Lordship may rely on 32, the vernacular one.
they took two signature, my lord.
सब इन्हें निवेदन है कि इस प्रकार से है कि प्रार्थी नंबर इतना राइफल विक्रम राणा महोदय, मेरे घर में स्थिति काफी खराब है। घर में मेरी माँ की देखभाल करने वाला कोई नहीं है, जिसके कारण से मैं अपनी नौकरी करने में असंभव हूँ। महोदय, मैं अध्यक्ष राइफल इतना अपील भर्ती हुआ था, मुझे निवेदन नहीं और सेवा समाप्त करने की कृपा की जाए। आपका आभारी रहूंगा, प्रार्थी सो एंड सो। Yes.
31 is different, my lord.
I think it's now my turn. I am the appellant here.
31 is different. How?
Different, my lord. Lordship will see.
That is part of his. This is
My
part of his.
personal problem. It doesn't say.
घरेलू स्थिति है, ठीक है। वो maybe the translation is not up to mark, but Hindi application is there.
There, Lordship. Then Lordship will come to page 40.
The original application page 32.
Lordship. Then Lordship, page 40, he says that he wants to withdraw. This does not bear any seal and signature acknowledgement of us. 40.
Learned single judge has not gone into all this.
Lordship.
That whether he has withdrawn or not. Ranjit Singhal judge simply said there is no satisfaction on the part of the committee that he has voluntarily submitted his resignation. This is what the Ranjit Singhal judge has said.
And Learned Single Judge has relied on the CRPF, that's policy guideline. But we have our own record of inspection, Lordship.
Yes, you just show us.
Lordship, the record of instruction 1 of 2004. The item that will be dealing the case is serial number 4, discharge on request oblique compassionate ground. At page
Number
3.
4, superannuation, pension, review board, retiring pension, this one.
Lordship, so yes, Lordship. Page 3, item, serial number 4, Lordship.
Page 3. Serial number 4, discharge.
Discharge at own request.
Yes.
The terms and conditions of service in respect of personnel in Indian Assam Rifle permit an individual to serve up to the age of 60 years. He may, however, elect to proceed on pension after completion of 20 years of qualifying service, for which no reasons are required to be given. If an individual seeks discharge at own request with tantamount to resignation or on compassionate ground before completion of 20 years of qualifying service, forfeits any right to pension. However, as per Assam Rifle Act 1941, an individual can seek discharge on compassionate ground after completion of 4 years of service in case of general duty GD and 8 years in case of technical trade without any pensionary benefit. A certificate as per appendix H and J will be in case of forwarding to the sector so and so. And or having more than 15 years of service. So Lordship, following this guideline, Lordship, the DG has issued one letter that I have, Lordship, furnished Lordship, that is on 24th March 2002, constitute a standing committee who will deal with it. So all this.
March 2009.
9. Following this, there is a standing committee, Lordship, who has dealt with the matter, Lordship. So all the guidelines has been followed, Lordship. And moreover, Lordship.
What are the guidelines?
This is the only instruction, Lordship. That record of instruction 1 of 2004. Lordship will find in the letter, Lordship, serial number 4, the committee will. So how to be dealt with that, Lordship, as you explained.
Yes, read.
The committee will examine the request of the individual to rule out the possibility that no pressure by any authority in this unit was exerted, perhaps is exerted over the individual to put up application for voluntary retirement or premature retirement before the completion of pensionable service. The committee will obtain the following certificate from the individual and enclose with the application forward to DGR record so and so. So this undertaking has been furnished, Lordship. He has furnished an undertaking, Lordship. That will Lordship find at page 36.
Page 36, he has simply said, I shall not be entitled.
I shall not
for
be
pension
entitled.
because rendered by Assam Rifle.
Lordship.
Where is that certificate? Certified that I have applied for voluntary retirement or resignation from before completion of pension at my own free will and no coercion, pressure or inducement, whichsoever.
Lordship, page 34.
34.
34, Lordship. proceeding of the board, Lordship.
This is the recording.
Lordship. Proceeding of board officer so and so for the purpose of to examine the application submitted by so and so to rule out the possibility of any undue pressure by any authority in the unit over the individual to put up application for discharge from service. Then finding, Lordship. The standing committee has found that no undue pressure or by any authority within the unit has been exercised over the individual who have applied for discharge from service, and that he has done so on their own volition due to his domestic problem.
Actually weakens their case. This finding weakens their case. एक ही दिन में without examining the. ये नहीं है उसके ऊपर इनका ये सेटिस्फेक्शन सेम डे में कैसा है ना तो कैसा नहीं it was being a certificate from Israel and it closes the.
Lordship, in this case, the dates are important because he filed application on
12/8/2011.
12/8/11. Then he claimed to have filed a petition withdrawing 26/8/11, which we have disputed.
That's leave it.
Leave it. We are leaving the 15/9/11. We 15/9/11. We approved it. 15/9/11.
24th of March 2009.
9/1/13. He filed the petition for the.
Just a minute. 24th of March 2009, premature discharge before pensionable service. Of late, it has been experienced by so and so when receipt of date of such so and so complaint to the senior, they were compelled by the CEO, other officers in the unit to sign the application for a discharge under the threat and duress. Voluntary premature retirement before completion of pension as approved by this senior after ascertaining the correctness and voluntary of so and so compassionate are submitted senior directed to the VIP government level. In view of the above, it has been decided that the case of the voluntary retirement completion of pension will be examined by the quarterly standing committee composed as under. Fine. The committee will examine the request of the individual, rule out the possibility that no process by any authority in the unit was over the individual to put the application for voluntary retirement or permanent retirement before completion of pension. The committee will obtain a following this certificate from the individual and enclose with his application forwarded to DGR records. Now, where is this certificate you just show us? This certificate is where this certificate?
For that, I want to call for the records from the office, Lordship.
You should have placed it on record, sir. When you have already placed this, his application and the order of the standing committee, where is that? Now you are on a very sticky wicket, Mr. Pansal.
Lordship.
And that's why only I think so that this court has earlier granted you time to amicably settle the issue.
Lordship, my submission will be on his conduct, Lordship. He has approached after more than 1.5 years.
Conduct will come later on. First of all, you satisfy.
The conduct is also important,
Has
Lordship.
been completed or not. Conduct will consider later on.
Oh, then I have to, Lordship, it kept it part heard, Lordship. I'll.
लिखिए learned concept for the appellant. Place for and granted time to place on record the proof that the standing committee before accepting the application for voluntary retirement of the respondent.
Voluntary discharge, I think.
Before accepting the application for his discharge, before accepting the application of the respondent for his discharge from the services voluntarily has obtained a certificate
As required under the letter dated. so and
As
so.
prescribed under the letter dated 24th of March 2009, issued by the, which is this officer is,
This is issued from the direct DG Assam Rifle, office of the DG Assam Rifle, Lordship.
DG Assam
Assam Rifle.
Rifles, full stop. List on Tuesday,
No, Lordship.
make it sure.
Next Tuesday, Thursday, Lordship.
Thursday, can you tell me? 13th of March. 13th of March.
The same day, the standing committee arrived at a satisfaction without even examining
But
him.
the
on
effect
what
was given,
basis?
effect was given after 90 days, Lordship.
No,
That
no,
scope
no,
was
but-
given to him. He could have withdrawn that.
But the decision was arrived on the same day.
Lordship.
What was the satisfaction? How? There's nothing in writing.
Only
Nobody was
because of haste,
examined.
Lordship. Doubt cannot be.
Even though, sir, even though if we exempt this, okay, same day they were convened the meeting and that committee was available and they had done it. Where is that certificate? This is
Lordship, the certificate
first
as
requirement.
required under this letter.
First requirement.
If we don't have this, otherwise, then here.
Or either if you don't have any such certificate, get it settled.
Yes.
Otherwise you will be,
The rules also provide, my lord, some rules also.
yes.
Item 21.
Impugn order, my lord, relevant portion page 369. my lord.
Yes.
My lord,
369,
369, my lord.
yes.
I read from the, my lord, paragraph 3, my lord. The petitioner contended that since the academic council, either of the Guwahati University or that of the Dibrugarh University, does not have such jurisdiction and authority to specify the relevant eligibility criteria for appointment to the post of assistant professor in the degree colleges, and as such, power is vested with the executive council of the respective universities. And to clarify such decision, therefore, the impugn notification number such and such dated 2/2/2022 issued by the academic register Guwahati University, as well as communication number such and such dated 12/1/2021 issued by the registered Dibrugarh University noted above, being bad in law, should be set aside and quashed. It is seen that the Academic Council of the Guwahati University issued the impugn notification dated 2/2/2022 pursuant to the order of the court dated 22/2/2022 passed in WPC 1034/2021, whereby the court directed that the Academic Council of this said university to specify their decision with regard to MSc degrees in the subjects of biotechnology, microbiology, and molecular biology, etc., vis-a-vis the subjects of botany and zoology in the degree colleges affiliated to the University, Guwahati University. Similarly, pursuant to the order of the court dated 17/11/2020, passed in WPC number such and such, the Dibrugarh University issued the notification dated such and such, clarifying its stand in conformity with the judgment dated 16/9/2019. It is to be noted herein that the order passed by this court on 22/2/2021 in WPC 1034/2021, as well as the order dated 17/11/2022 passed in WPC such and such, are still valid and stands affirmed, not being challenged by any other higher forum. Therefore, the decision of the Academic Council of the Guwahati University dated such and such, as well as that of Dibrugarh University dated such and such, impugned in this writ petition, being passed by the authorities of those universities pursuant to the directions of the court, shall stand valid, unless those decisions orders of the court allowing the academic councils of those universities to take a decision in that regard are modified or reviewed in the review petition by the concerned court, or modified or set aside and quashed in a higher forum, like in writ appeal and appeal. For the reasons above, as those notifications dated such and such issued by the respective academic councils of the universities pursuant to the orders of this court noted above, being still valid and are in force till date, this writ petition being devoid of merit and dismissed. What happened, my lord? The earlier round of litigation where this petitioner was not party, and that writ petition, this honorable court given a direction to the academic councils of the respective universities of the state of Assam, directing them to take into consideration whether the biotechnology is equivalent with regard to that of zoology and botany, my lord. That decision was taken by the academic council that it is not equivalent. But as per the statute of the Guwahati University, my lord, that is power and functions of the Guwahati University and all the universities like that, my lord. And that does not empower the university to make such a academic council to make such a decision with regard to the recruitment conditions of the state government. And that is the ground this honorable court has given the interim protection to the petitioner. And in this regard, my lord, my humble submission is that
Judgment of this court is there.
Yes.
Directing the academic council to decide
Yes.
the question of equivalence.
Yes.
And that judgment is still not reversed or modified or reviewed.
Yes.
What's wrong with the academic council has to
No.
take a decision
No, my lord.
to comply with the court order.
They have to, that court, while deciding the earlier round of litigation, my lord, at that point of time, the relevant provisions of with regard to power and functions of the academic council of the university, that was not brought before the honorable single judge, my lord.
You should have challenged that order.
That order, my lord, in that proceeding, I was not the party, and I am been affected. I have been affected by the
Ask for leave.
resultant order. And that's why, my lord, this honorable court.
If whatever it may be, the judgment is wrong or right, and if they have complied with the order, how can we find fault with the?
It is why it is wrong, my lord, because in the writ appeal, my lord, division bench can, my lord, take into consideration.
Without there being that specific judgment is under challenge, how can we go into all this?
Specific judgment is there, but we approve on the separate cause of actions, my lord.
Nothing wrong with this order. We don't find any illegality in that. That if don't know if your clients are advised, telling those orders, then only we can consider that, but otherwise no. Or you can file an application for review seeking leave from that court that the academic council has no authority to decide the equivalence, and it is only the executive council. The court may
My lord, may grant me some time, my lord. I will.
seek your instructions, otherwise so we don't find any illegality in the orders.
Honorable single judge also indicated, my lord.
the single judge, and it was for the single judge to take a different view.
Single judges said it, we are saying it. Do you want to hear it from Delhi also now? If you wish to, then we can give you a way out.
As some time may be granted, my lord, I will take instruction.
Tuesday,
At least for 1 week time, my lord.
1 week हो गया ना? Next week ही दे रहे हैं.
This week.
Wednesday.
Item 23.
Please, Lordship. In this case, I am handicapped because somehow, my lord, from our office, my lord, brief is misplaced, my lord. May I pray, my lord, next week, any day, my lord. Obliged.